Any mention?
Okay. Yes,
Lordship,
Mr.
I'd like
Upadhyay.
to mention item number 12, Lordship.
Yes.
Lordship, a matter is pending before this Honorable Supreme Court, which has a direct bearing on this.
Earlier it was recorded.
Yes, Lordship, it was.
Okay. Correct? Yes. Mr. S.D. Upadhyay, learned counsel for the petitioner, submits that the connected matter is pending before the apex court, is yet to be disposed of.
Yes.
In view of the submission, list this matter after
4 weeks, Lordship.
4 weeks.
Please, Lordship, I beg to mention item number 20, Lordship. I have informed to the other party also, private respondent and also the government also, Lordship.
Item number 20.
Lordship, is for
20.
20.
Yes.
Just beg to mention after, it may come after some time, after 2 weeks.
No objection, my lord.
Yes. Item 20. On the request of the learned counsel or the petitioner, list after 2 weeks.
Lordship. First place, Lordship.
Lordship, I beg to mention item number 13, Sangeetapun.
1-3. Yes.
Lordship, it may appear after 2 weeks. Item number 13.
Oh, there is that service matter.
Yes, Your Lordship.
The court has forgotten everything. So.
Yes, Your Lordship. Your Lordship, we were supposed to place some decisions, Your Lordship. On the last occasion they had said that.
So on that ground it was adjourned.
Yes, Your Lordship.
Okay. Any objection?
No objections, Your Lordship.
Okay, on that prayer made by the learned counsel for the petitioner, list this matter after 2 weeks.
Obliged, Your Lordship.
Highly obliged.
May it please, Your Lordship. Your Lordship, we beg to make a joint mention of item number 14.
Yes.
Your Lordship, I pray for 2 weeks' time, Your Lordship.
What is that case about?
482, Your Lordship.
Quashing.
Yes, Your Lordship.
After 2 weeks. 14. No
Yes, Your
objection.
Lordship. No objection, Your Lordship.
Okay, 14 also. On the request of the learned counsel for the petitioner, after 2 weeks. List. Yes.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 15, Your Lordship. Let this matter be taken up next week, Your Lordship.
Item 15.
Yes, Your Lordship.
Yes.
Lordship, I'm further responding.
That was the matter which was heard at some length, is it?
Yes, Your Lordship. Because we have received the letters, Your Lordship, from the respondent, so we need to obtain the instruction from the client, Your Lordship. So, because the client is our station, so we need some time, Your Lordship. Let it come next week, Your Lordship.
Okay, item 15. On the request of the learned counsel or the petitioner, list after 2 weeks.
Next week, Your Lordship.
1 week. Oh,
Next week,
list
sir.
after 1 week.
Highly obliged.
Much obliged, Your Lordship.
Lordship, I beg to mention item number 6 on behalf of the respondent. Here we are supposed to obtain the copy of the award of the LA proceeding. We are yet to receive from the Deputy Commissioner's office. I'm praying for 3 weeks' time, my lord.
Was it hard at any level?
Yes.
Not the matter, lag matter.
And my lord was of the
Produce that award paper.
the award. There was nothing on record.
Too many matters, Mr. Sangresho. It was hard and unnecessary, useless things. The problem is that at a certain game, court also forgets those things.
Exactly. There were
And you have to redo the hearing again, the consumption of same.
Right. So 3 weeks are too long, man. They have enjoyed 2
No,
weeks.
I have already
earlier.
written once. Now I'll again write back to the Deputy Commissioner concerned to get the copy of the award, my lord, because there was nothing pertaining to the LA proceedings.
What was the last order passed by this court? Was there anything
Yes, to produce,
produced?
to obtain the recorded.
That has already gone into the record.
So I'm praying for some time. 3 weeks' time, my lord.
3 weeks are too long. It is an old matter, man. Very old matter.
2 weeks, my lord.
Okay, on the request of the learned State Council, This matter after 2 weeks. Item 6.
Mine.
Lordship, I'd like to mention item number 16. 16, 17, 18, they are connected matters on behalf of Mr. Shulai.
He's still not well.
He's still not recovered.
Any problem with his sugar?
I'm not sure.
Mr. Congratulations, yes. 16, 17, 18. All will be same order. On the ground of absence of Mr. Andy Shulai, learned counsel appearing for the respondents on account of ill health, comma, list this matter after 2 weeks.
Highly obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 7. Your Lordship, I'm for the respondent number 5, Your Lordship. And the conducting counsel here, he is not well. He is suffering from cold.
Who is conducting counsel?
Sir, M. Qureshi.
Qureshi, Mr. Qureshi.
Yes, Your Honor.
No objection, Lordship.
Your
If that-
Lordship, if number 7 is adjourned, Your Lordship, number
8 and 10 also, it's connected matter, Lordship.
8 and 10 who are repairing?
10, yes.
10,
Your Lordship,
Lordship,
they are the petitioner.
petitioner in item 10.
In 8 and 10 you are petitioner.
No, Lordship, just item 10.
Then 8 who is there?
8.
You are the petitioner.
Yes,
7
Lordship, 7
also
and
you are
8.
petitioner.
Yes, Lordship.
Any objection in any of the cases, any if it is urgent? Yes, Mr. Sheikh.
I'm for the 8 and 7 and 8, Lordship.
The time has been sought by the Ten, who is the other side? On the respondents? You are the petitioner.
I am for the respondent number 5.
Private respondents are Qureshi is appearing in item number 10.
10 is also tagged together with this?
Yes, Lordship.
Okay. Then this item 7 on the request of the learned counsel appearing for the private respondent number 5. List this matter after 2 weeks. And then 8 and 10.
10, Your Lordship, I'm for the item number.
No, that is all right. But then is there any order to tag those
Yes,
things
Lordship. There is an
together?
order, sir. There is an order, Lordship.
So 8 and 10 just say list after 2 weeks.
7, 8 and 10 is.
So 8 and 10 just say on the request made by the parties. List this matter after 2 weeks.
Obliged.
Just verify whether separate orders are passed in those things or not, and then. All right.
Obliged.
Come after 2 weeks.
Obliged.
Me please, Your Lordship. Lordship, I beg to make a mention on item number 4, Your Lordship.
Item number?
4, Your
4.
Lordship. Lordship, in this matter, we are supposed to file a substitution application, Your Lordship. But instruction is awaited, my Lord.
These are what? Nokma matters?
Nokma, Your Lordship.
And what for you are seeking adjournment?
We are supposed to file substitution with regards to petitioner number 1, Your Lordship.
Petitioner is no more.
Yes, Your
How
Lordship.
many petitioners are there?
2, Your Lordship. 3.
And then who died?
My Lord.
Who passed away? Which petitioner?
Petitioner number 1, Your Lordship.
Number 1.
Yes, Your Lordship.
When? Passed away when?
That I'm not sure, my Lord.
The petition is barred now. It will be barred now.
My Lord, may kindly 2 more weeks.
Yes.
We don't have any objection here.
Item 4 on the request for of the learned counsel for the petitioner, release this matter after 2 weeks. Only item 4.
Yes, my Lord.
Much obliged.
Very obliged, Your Lordship.
Remaining.
Your Lordship. Your Lordship, I beg to mention item number 3.
The conducting counsel is out of station, Your Lordship.
Who is conducting counsel?
Mr. Icharnath.
Was it hard at some length?
Yes, my lord.
That land acquisition.
Yes, yes. My lord. They are demanding compensation
So, Your
without
Lordship.
acquiring the land.
Your Lordship, I pray that this matter may be come up after 2 weeks of time.
These matters are hard at some length, we would like
Yes.
to dispose it of. You say like the
Yes.
problem is that with after certain gap, even the court also forgets the thing. This is a problem. Well, just right. A request has been made on the behalf of the petitioner on the ground that the conducting counsel, Mr. Icharnath, is out of station. You just say a request has been made to adjourn the matter on the ground just adjourn the matter for 2 weeks on the ground that conducting counsel, Mr. Icharnath, also. The prayer has not been opposed by Mr. Hajarika, a learned state counsel. Accordingly, we'll list this matter after 2 weeks.
Much obliged, Your Lordship.
Minus item number 1.
Please, Lordship. Today, we have received some working document filed by the.
These are not new documents, isn't it?
Synopsis, my lord.
This is synopsis, but they're not new documents. These documents are already there.
Document. It is existing document.
But then these are
It is really chronological event I have arranged.
Your Lordship, even then, if we saying that all the documents are enclosed, if we go by the annexure that was filed, annexure 133, Lordship, he claimed that all the series, whatever document is there, he's saying that. My only saying is that if he is enclosing the document,
you will get the
enclose the
time.
document.
If you are asking for time, you will get it. But then one thing is that the documents in order in which order it should be placed and all. Why you are bringing it to this thing? You can sort it out between yourself.
No. I'm not saying. My submission is that he said that he has enclosed all the document chronologically as what is in the axis. Even till now, also, he has not even enclosed all the document. This is not there. That's why
there are some documents missing.
Some documents are still missing.
That is what this court is precisely telling you. Please understand and appreciate. If you find something is missing, why don't you communicate with him and then get it included?
Today only he has given.
That is all right. They say that court is inclined to give you time to this thing to verify it. Let him, Mr. Hajarika.
Yes,
if he says that there are certain documents missing, if he points out, please.
Yes, let them indicate me what are the documents.
Because otherwise, you see, like the way it is arranged in this writ petition, it will not be possible to come to any conclusion, at least for this court.
Yes. So that is the reason I have submitted this one.
Otherwise, my lord, at this time of hearing, can he just bring all the document now issued? Without it was maybe some documents are out of context also because
what is this synopsis? That means what?
Synopsis is
it has come as a statement.
Yes, my lord.
There is an order in the order 21/9/2023. He only asked him to file just a synopsis, not a document. Is there in the order, and he has filed it also.
Made again a prayer like petition and all. It was not at all required.
And on 10 August 2023, he has filed a synopsis. Again, this is another synopsis.
Yes, as per the court
Twice.
order.
See, it doesn't matter. See, synopsis has to be in chronological order. That is why. It is a comprehensive synopsis. That is what is needed. Okay. But then why it has come with these averments and all, Mr. You should have given only the list of documents and nothing.
No. Here I will precisely only for this synopsis I have given along with this what are the I have mentioned. So that because all the document, my lord, it is some are in the writ petition.
So it has not come as a petition, isn't it?
No, my lord. No.
If we go by the pleading, it's like a pleading only. This is the new pleading. It's like a writ petition only.
No new thing has come up.
Not new thing. He has filed two synopses. Another is pleading. Now the new things is coming up with new things. This petition is different from the original writ petition. If we compare the writ petition which was filed earlier and the synopsis is also like a writ petition only. They have order 2, 3, 4, 5, 6, 7, 8, 9, 8 till 8 point. The pleading also is different.
Do not go by format. Okay, if it doesn't come as a petition, if it is not supported by affidavit, this statement will have no value.
Lordship.
Okay.
Yes, Lordship. In the meantime,
Lordship, only for the purpose of making courts work easy, so that you get a reference of the contents of the document.
Lordship, I just want to submit, if anything is missing, I also maybe just allowed to file some document.
Yes.
That document.
Mr.
Something which is missing.
Yes, Mr. Day. Let him verify the thing. Let him verify.
If only thing I want to point out, I will also examine the synopsis. But if any additional document come before that move,
that will ignore. If it is not a part of record, We'll just see which way to deal with that.
Yes. Okay. No problem.
When this order was passed for asking you to file a...
On 21st 9 2023, that order is there. After that, there is another order. This one. Here, this is the
1110.
1110. Nothing is recorded in that.
Okay. It's okay.
As per the order, yes.
It's all right. No problem. 21.9 is there. Written argument. Mr. H. Hajarika, Learned Counsel for the petitioner, submits that he has prepared a comprehensive synopsis in the matter. A copy, whereof is furnished to the Learned Counsel for the respondents. Stop. Mr. P.T. Sangha, Learned Counsel appearing for the respondent number 4 and 5.
Your Lordship.
Submits that he has received the synopsis only today.
Today morning only.
During the course of the day only, and would like to go through the same matter before the matter is taken up for hearing.
If anything that I
may
for
grant of some time,
yes,
to do the same.
Lordship, there is one document he has. No, can I just allow to file it, because this is on the part of record. It is there.
You just verify it and you submit on the next day that whether it is what is there and what is not there. Just you can make these things.
Yes, they can indicate it.
Yes,
you can indicate if something is missing. You can give supply it to us also.
Yes, okay, it may be recorded too, because I will just prepare the order.
That is what we are saying.
Lordship.
You need to go through. That is what.
Lordship.
Just tell me the last one. Mr. P.T. Sangha. Only during the course of the day, and would require some time to stop. Stop. No, it's okay. This already you would like to do these things. Stop. Give a stop accordingly. This is matter after. No, you just say in view of the submission. No, say accordingly. In view of the submission, this is matter after when?
After 2 weeks. No, after 2 weeks. After 1 week, because this is pending for long, Lordship.
Sure.
This maybe next week, any time, Lordship, any date on the next week after 1 week, Lordship.
Shall we retain it?
No, it can be written, my lord, because all the chronological events.
This is very thick.
Yes.
Yes.
Item number 9.
First, Lordship.
Yes, Dr. Majika.
Mr. Jhawal.
Where is he?
I've not seen him for a few days already. 2-3 days last he's not there. But this is a case, my lord, that this on medical ground the petitioner was dismissed from service.
In continuing
for alcohol consumption, my lord.
And he is continuing service. Oh no, not this one. Not this one. So what is to be done? Was it heard at some length?
It was heard at some length.
Well, then what is the use of hearing also? You see, until I understand.
Since
we'll take it on some other day then.
2018 matter.
Can you dismiss it for one default?
I'm not.
We'll just see
Because
if
of delay,
it
the
doesn't
relief-
appear on the second.
Because of
occasion.
delay, my lord, the relief becomes more difficult for petitioners. They're defeating their own case, my lord.
Definitely. They're defeating their own case. You are correct, actually. This none appears for the petitioner. Dr. Majika is present on behalf of the respondent. Stop. In the interest of justice, list this matter after 2 weeks. Well. Obliged.
Item number 11.
Yes.
My lord, this matter pertains to foreigners, the Nigerian national.
Yes.
As per the last order, Lordship, the petitioner had undertaken to make some corrections in the statements that were read out. It is quite voluminous, so I'm praying for 2 weeks' time more.
Lordship, I have prepared, Lordship.
Then in that case,
correction I have prepared. Correction of the type copy of the
You have
questions.
prepared.
I have prepared. Lordship.
Then
Well, given a couple of copy to him.
I'll give him copy, then
We can have it after.
we can go for another day.
Okay. Then we will record that. That he has prepared it. You have prepared the entire evidence.
Prepared all the witnesses, 6 witnesses.
Mr. H. Khanvi, Lorette, GA, submits.
Additional, this criminal
Sorry.
matter, additional PP, Lordship.
Additional PP. You correct me. You see, like I always forget who is what. Even the names also, especially for newcomers, I do not remember. It's a problem. Anyway, Mr. H. Khanvi, honest additional PP submits that the corrected copy of the submits that corrected copy of evidence in this matter has been prepared, and a copy of the same would be supplied to the learned counsel for the petitioner during the course of the day.
Yeah, it's ready. I'll apply to supply to it.
Stop. What shall we say? You will verify it, or is it needed?
No,
not
not
needed.
necessary.
Okay. So is it? Then we can list it when.
1 week or so. 1 week.
Anytime, my lord. To my limited understanding, my lord, I think the court won't be required to even to go into the evidence of the, because as I have been acquitted from the mischief of section 469 and 71, what remains to be decided is whether I can be convicted under section 14 of the Foreigners Act. And admittedly, my lord, I was arrested in the month of June, and it was my visa was valid till the month of October. So at that point of time, my valid was visa. Once I have been acquitted from 469, 471, what's the question?
The allegation was that you forced that extension of visa.
Yes.
That was the thing.
Yes. So I
that
have been
forgery
acquitted.
charge did not stand.
Well, that is not challenge even the finding of the.
Lordship, on the next day, I'll just reply.
Okay. So, list this matter for a hearing after 2 weeks.
Debrief. I don't have much submission.
So, then you say on the request of the learned counsel for the parties, list this matter after 2 weeks.
Much obliged. Deeply obliged.
Item number 19.
Lordship, before going through the file, Lordship,
Yes.
may kindly recap. It's a matter where the pardon has been granted by the learned trial judge. So I am impugning that very judgment, my lord. Lordship may kindly peruse the PC Act Section 5, my lord. May I invite attention of this Honorable Court, Section 5 of the Prevention of Corruption Act.
Give us the fact, Mr.
Lordship, the fact is this. that the Raghavendra Pratap Tripathi, who has been granted pardon, he came to the court after 805 days, 2 years, 2 months and 15 days to the Honorable Court and filed his application on his own that I want to disclose the full truth to the court during the examination in chief, and therefore I should be pardoned. The application has not come from the prosecution, that is CBI, my lord. And we opposed there in the trial court on the statutory ground, my lord, because the learned trial judge cannot exceed the statute during the course of the proceeding. So now, my lord, I am referring this section 5, my lord, may kindly peruse section 5, wherein this statute empowers the learned trial judge for the purposes of all the proceedings before this court. Section 5, my lord, of this act. Lordship got it? Section 5,
Yes.
my lord.
Yes.
Procedures and powers of the special judge. This is the section 5 subclass 1, my lord, and then subclass 2. But I'll be reading subclass 3, specific, my lord. Save as provided in the subsection 1 and 2 of the provisions of the Code of Criminal Procedure shall, so far as they are not inconsistent with this act, apply to the proceeding before a special judge for the purposes of said provision, my lord. Now, it's mandatory, there is a shall that the court shall conduct the trial in accordance to the criminal procedure, but any act which is anything which is repugnant to, inconsistent to this act, the trial judge shall not act upon, my lord. There is a bar to the trial judge under section subclass 5, section 5, subclass 3, my lord. A specific bar, my lord. Now, my lord, I'll be referring to my lord, the page 9 of my petition, my lord.
What is the impugn order?
Lordship, impugned order, my lord.
Let us first go to the impugn order. This court must understand, you see.
Lordship, the impugned order has not even discussed my lord, impugned order.
Please read out the impugn order. Please read out the impugn order. Let us go to the impugn order.
Okay, my lord, I'm reading the impugn order. Lordship, I'm reading from the page 1. The case has come up for consideration on the application filed by the accused Raghavendra Pratap Tripathi for the grant of pardon under section 306 IPC registered as petition 93 dated 4/12/2021, my lord. The case in brief is that the case to be registered on 23/11/2018 on the basis of written complaint dated 22/11/2018 of Sri Raghavendra Pratap Tripathi, PhD A3. He was the student under the petitioner as a student of Department of Biomedical Engineering, Northeastern Hill University, Shillong, Dr. Dinesh Bhatia, Associate Professor and Head of the Department of Biomedical Engineering, Department Northeastern Hill University, Shillong. It was alleged that the complaint of Dr. Dinesh Bhatia was Dinesh Bhatia was indulging fraudulent practices and threatening to the complainant to hand over him the proceeds of the fake bills sanctioned by him in the following firms. Here, Lordship, may kindly pause for a second. Allegedly, under my supervision, forged bills were prepared by the Raghavendra Pratap Tripathi. And when I was allegedly putting pressure on him for preparing forged bills, that time too he did not disclose anything to any law enforcing agency. With / SK Enterprises, Regi Medical Stores, MS Vindhya Vashini Enterprises, it was further alleged that the amount of 45,000 was deposited in the bank account of the complainant by one Ranjit Kumar Gupta, which was the proceed of the fake bill sanctioned by Dr. Dinesh Bhatia. Out of this, Dr. Dinesh Bhatia has asked the complainant to withdraw 40,000 in cash and hand over to him. Since the complainant did not want to hand over the legal gratification of rupees 40,000 to Dinesh Bhatia, he lodged a written complaint with the CBI ACB, Shillong, to take necessary legal action against the Dinesh Bhatia. After completion of the investigation, CBI filed a charge sheet under section so-and-so, as amended so-and-so under section 120B, 420, 468, 468, 471 IPC against the accused, Professor Dinesh Bhatia, Associate Professor at Department of Biomedical Engineering, NEHU, and Dr. Ranjit Kumar, Sri Raghavendra Pratap Tripathi. Charges were framed against the accused persons, Professor Dinesh Bhatia, Department of Biomedical Engineering, which they pleaded not guilty. However, the charges are yet to be framed against Raghavendra Pratap Tripathi. White application 93 dated so-and-so, the accused Raghavendra Pratap Tripathi has filed an application under section 306, Malad. No application has been filed in section 5 subclass 2, Malad, of the PC Act, which is a special provision for the grant of pardon and to consider him as an approver. CBI filed their response stating that they have no objection to the prayer of the petitioner, accused A3, he may be granted pardon under section 306 and to be considered as an approver. Malad. CBI has not forwarded.
Here the complainant is same person, isn't it? Raghavendra Tripathi and Raghavendra Pratap Tripathi, same person.
Yes,
now the case was registered on the complaint of his, and then he was made an accused here also.
He was made an accused.
Yes, Malad.
Because the money came into his account.
Yes, Malad. The accused Dinesh Bhatia filed his objection on the following grounds, Malad. That the proposal to pardon Sri Raghavendra Pratap Tripathi and to turn him into an approver did not originate from the prosecution, as in the charge sheet the CBI made the accused Raghavendra Pratap Tripathi as an accomplice, and sudden changing course by the CBI is causing prejudice to so-and-so. The CBI, after considering, now Milord, here to mention with all apology, it was not my argument. My argument was that the cap of protection under section 24 of the Prevention of Corruption Act has been taken away by the
Do you want to say that your submission was not recorded correctly by the trial court?
Yes, my lord, it is, my lord.
You cannot raise it here. You cannot raise it here. If you want to raise it, you go to the trial court, file the application there. That is what the Supreme Court says.
But I am apprising this honorable court, my lord.
No, that will have no bearing, see.
Please,
it will not have bearing. But then if you come with that thing, then definitely the proper score is to go there.
No problem, my lord. There is no problem, my lord. That the CBI, after considering the evidence, sufficient charges has charge sheeted all the accused persons, including Raghavendra Pratap Tripathi, and the evidence and assistance of Raghavendra Pratap Tripathi not required.
This Raghavendra Pratap Tripathi is a party here in this case.
Yes, my lord. It is a party. He was a party there also.
Is he appearing here?
My lord, he is appearing. He is appearing. He is a party.
Who is through whom? He is appearing through whom? Who is his counsel? Dr. Please, you can please help the court. You see, it is very difficult. The BC things are not very clear. I do not get it.
What is suppose?
He was appearing, my lord.
14th August.
He was appearing.
Notice was given to him.
Respondent number 2 was represented through Esthapa.
That is a respondent too, my lord. He was a lawyer were appearing, my lord, on behalf.
Yes, Thapa.
And they had been.
Is he Mr. Thapa who is attached to Mr. K. Paul? No, my lord.
And they have not filed
no
the response on the.
They didn't make any mention also.
Lord,
it should not be something like that. You see, like we proceed ex parte just because of the absence of a lawyer. If they are here, then we can definitely.
Lordship, can I submit?
Yes.
Can I submit, Lord? Lordship directed them to file their objection, but neither CBI took 2-3 days, but they have not filed, and even the respondent too did not file any objection before this honorable court. Now they said, okay, I'm ready for the argument. And then my lord was pleased to put it up for argument. On the last date, I was not well, my lord, so I could not appear.
Yes, yes, just hold on for a moment. Just hold on for a moment.
Please, my lord. Please, my lord.
They appeared till 14th 8th, man. 14th August. After that, on 3 dates, they have not appeared.
This matter was earlier heard at some length by the other bench.
No,
Subsequently, you were supposed to file an affidavit to clarify certain things. Now you have not filed it.
My lord, we have gone through the order. Order says, my lord, the CBI stand before the trial court was that we have no objection to granting of pardon.
But in response to certain queries, it says.
But that was the query, my lord. That was the question put to me, my lord, was whether whether CBI supported granting of pardon or opposed it, my lord.
Lordship, can I submit, my lord? Lordship, can I submit?
Just one minute. Hold on.
Please, my lord.
Yes, please.
Lordship, for few seconds, kindly peruse section 24, my lord. Section
Yes.
24 of the PCS, my lord.
You have a speaker near you. See, the sound sometime it goes low, it becomes difficult to hear. You see,
I'm sorry, my lord, I'm sorry.
I do not know whether it is because of your system or because of our system. But then
No, is that okay, my lord?
it seems okay. You see, sometimes it's okay, but then sometimes it dips down. I don't
So,
know.
my lord, may kindly peruse section 24(1) for few
Let us read the judgment first. Let us come. See, this court has not got.
Acha, please, my lord.
Perhaps you
Please,
might
my
have
lord.
argued it before some other court, not before this court.
Please, my lord.
Yes.
So, my lord, I'm reading from the second paragraph. The accused Raghavendra Pratap Tripathi has concealed in his FIR his direct involvement in the procuring rubber seals in the name of 3 enterprises, so and so, my lord, for using it in the fake bills and other documents. It shows that he is not making full and true disclosure of the whole of the circumstances within his knowledge relative to the offence. So, by claiming that he will make full and true disclosure privy to the offence in totality before the learned court is something to be treated with caution. The CBI by not objecting to the petition filed by the accused Sri Raghavendra Tripathi for grant of pardon was with a view to shield the accused. As in the charge sheet, the CBI made the accused an accomplice, and a sudden changing course of the CBI is perplexing and causing prejudice to the accused Dinesh Bhatia. The accused Raghavendra Pratap Tripathi has filed the application seeking to be an approver in order to save his own skin and not in order to help the cause of justice, as he has concealed the material fact in the FIR, like procuring rubber seals in the name of 3 companies, firms, and would amount to premature vilification of the accused Dinesh Bhatia. The Raghavendra Pratap Tripathi, being a trap witness as well as seeking to be an approver, cannot be considered to be a competent witness. He is being participant in the commission of the offence by offering alleged money, shows a clear and bona fide criminal intent of getting Dinesh Bhatia implicated falsely. In support of the contention, the learned counsel relied on the decision of the Commander Pascal Fernandez versus State of Maharashtra. And then, Lord, the learned judge has rewritten section 306, my lord. If Lordship asks, we will read it. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned to, in preview to an offence to which this section applies, the Chief Judicial Magistrate or the Metropolitan Magistrate or the investigation or inquiry into the
I'm
trial.
calling.
Yes, one.
You may continue, my lord. My friend is here. 1 minute, my lord.
Yes. Please proceed. Yes.
Trial of the offence, magistrate for the first class inquiring into the trial, trying the offence at any stage of inquiry or trial may tender a pardon to such person on condition of his making a full and true disclosure of the whole circumstances within his knowledge relative to the offence and even every other person concerned with an principal or abater in the commission thereof.
Yes.
The section applies. Ground 2 section applies subclass A as written by the learned judge. Any offence triable exclusively by the court of session or by the court of a special judge appointed under section criminal law amendment so and so. Any offence punishable with an offence may not extend to 7 years or with a more severe sentence. Every magistrate could tender a pardon under subsection 1 shall record his reasons for so doing, whether the tender was not accepted by the person whom it was made, and shall application made by the accused furnish him with a copy of such record free of cost. Every person accepting tender of the pardon made under section subclass 1 shall be examined, page 4, my lord, shall be examined as a witness in the court of the magistrate taking cognizance of the offence and the subsequent trial, if any. B, shall, unless he is already on bail, be detained in custody until the termination of the trial. Whether person has accepted a tender of pardon made into subsection 1 has been examined under section 4 of the magistrate taking cognizance of the offence shall, without making any further inquiry in the case, commit it for trial. The court of session of the offence is triable exclusively by the court, or if the magistrate taking cognizance is the chief judicial magistrate, subclass 2, to a court of a special judge appointed under so and so, triable exclusively by the court in any other case, make over the case to the chief judicial magistrate, who shall try the offence. With regard to the objection raised by Dinesh Bhatia, reference is made to the decision by the Lieutenant Commander Pascal Malan, relied upon by the accused Professor Dinesh Bhatia. In reference is also made to the decision of the Suresh Chandra Bahari versus State of Bihar, 1995, my lord. Commander Pascal Fernandez versus State of Maharashtra. In this case, the special judge made no effort to find out what Jagasia had to disclose. English law and the practice is to omit the proposed approver from the indictment, or B, to take his plea of guilty or arraignment or offer no evidence and permit his acquittal. Enter a nolli provision in our criminal jurisprudence. There is a tender of pardon and condition of full disclosure. Section 8.2 of the pardon, Section 8.2 of the Criminal Law Amendment Act is enabling without recourse to an accused person cannot be examined as a witness in the same case another accused. Determine whether the accused's testimony as an approver is likely to advance the interest of justice. The special judge must have material before him to show that the nature of testimony will be ordinarily, it is for the prosecution to ask for the particular accused, not of the several may be tendered pardon. But even where the accused directly applies to the special judge, he must first refer to the request to the prosecuting agency. It is not for the special judge to enter the ring as a veritable director of the prosecution, and the power which the special judge exercises, it is not on his own behalf, but on behalf of the prosecuting agency, and must therefore be exercised only when the prosecution joins the request. The state may not desire that any accused be tendered pardon because it does not need approver's testimony. It may also not like the tender of the pardon to the crime or to the worst offender. The poor course of the special judge, proper course of the special judge is to ask for a statement before the prosecution on request of the prisoner. if the prosecution thinks that the tender of pardon will be in the interest of successful prosecution of the other offender, whose conviction is not easy without approver's testimony, it will be undoubtedly agree with the tendering of pardon. The special judge or the magistrate must not take on himself the task of determining the propriety of the tendering pardon in the circumstances of the case. The learned special judge did not bear the consideration in mind and took himself something from which he should have kept aloof. All that he should have done was to have asked the opinion of the public prosecutor on the proposal. But since the public prosecutor, which appearing in the High Court, stated that the prosecution also considered favorably the tender of pardon to the Jagasia, we say no more than the condition caution magistrate and the judges in the matter of pardon, tender of pardon, so motto at the request of the accused. This practice is to be avoided since the prosecution in case also wants the tender of pardon be made. It is obvious that the appeal must fail. It will accordingly be dismissed. Now, Suresh Chandra Bahari Lordship, the learned judge, has cited. We have already reproduced the section 306 of the code, of which apply to any offence triable exclusively by the court of session judge, a special judge, or any offence punishable with imprisonment extending to 7 years, with a more serious sentences. Section 306 of the code lays down a clear exception to the principle that no inducement shall be offered to a person to disclose that he knows the procedure, since many a time the crime is committed in a manner for which no clue or any trace is available for its detection, and therefore pardon is granted for apprehension of any offender for the recovery of the incriminating objects and production of evidence which otherwise is unobtainable. The dominant object is that the offender of the heinous and grave offences do not go unpunished. The legislatures, in its wisdom, considered it necessary to introduce this section, and in continuing the opinion to cases mentioned in section 306, the object of section 306 therefore is to allow pardon in cases where the heinous offences is alleged to have been committed by several persons, so that with the aid of the evidence of the person granted pardon, the offence may be brought home to the rest. The basis of the tender of pardon may not extend of the culpability of the person to whom pardon is granted, but principle is to prevent the escape of the offender from the punishment is heinous offence for the lack of evidence. Therefore, there can therefore be no objection against tender of pardon to an accomplice simply because in his confession he does not implicate himself in the same extent to the other accused, because of all 306 requires is that the pardon may be tendered to any person believed to be involved indirectly or indirectly. In view of the above decision, there is no merit in the objection of Dinesh Bhatia, my lord, and then operating portion, that is the ratio, my application was dismissed and he was, I'm not reading every sentence, my lord, and then he was granted pardon, my lord. My lord, with folded hand, my submission before this honorable court is, my lord, that now, my lord, may kindly read section 24 of the PC Act, my lord.
Section 24 of the PC Act. It was not
Yes, which has been deleted, but previous
which has
section
been
is underlined written, my lord. Underlined written, my lord. I raised this, my lord, a statement by bribe giver not to subject him to prosecution, my lord. Now the section so deleted is mentioned under para. Section reads before commission stood as under. Now I'm reading, my lord, from the underline, under para. A statement by the bribe giver not subjected to prosecution, notwithstanding anything contained in the law for the time being enforced, a statement made by a person in any proceeding against a public servant for an offence under section 7 to 11 or under section 13 or 15 that he offered or agreed to offer gratification other than the remuneration or a valuable thing to the public servant shall not be subject to such person to a prosecution under section 12, my lord.
What relevance it has?
No, my lord, this protection has gone wide amendment dated, my lord, 27.
You are what? Your allegation against you is that you are a receiver, gratification receiver.
Yes, please, my lord.
Yes.
And
then
the respondent to is the respondent to is the giver, my lord.
Respondent number 2 is the giver.
Giver, my lord. Bribe giver.
No.
So, my lord,
how? Where is that? The respondent number 2 means the person who has been given pardon, isn't it? Who has been granted pardon?
Yes, my lord.
No, it is not that. He is not bribe giver.
No, my lord, he took out 40,000.
No, it is not that. His money came to his account. That is the allegation.
My lord, it is there. I'm reading again, my lord.
No, let us see. What is the allegation against you?
There was one more accused in this case. It was not
my lord.
He is actually the bribe giver. There's one more accused in this case who is allegedly the bribe giver.
No, his participation is necessary here.
But if he is saying, my lord, if your Lord Snell Senior is saying that the bribe giver ought to be heard, then he's a necessary party in this case.
No way.
Respondent number 2 is a.
No way. This Tripathi is not a bribe giver.
No. Respondent number 2 is not a briber.
I do not know exactly, but then what revealed from that order, impugned order, is that yes, this amount came to his account.
That was the modus operandi.
My lord, the allegation is, my lord, this particular professor was purchasing few articles for laboratory, my lord. Without receiving the article, he only raised the bill to a firm in UP, my lord, somewhere. He is the accused number 1, the bribe giver, my lord. So instead of taking the money directly in his own account, my lord, the professor, what he did, he had a research scholar, this Raghuvendra Tripathi. So he asked him to deposit the money in his bank account. Actually, it's quite complicated. Three-part transaction, three-way transaction, my lord. My lord, what is happening, my lord?
No, my lord, my submission.
I can just let us get the fact, Mr. You have not given us the fact. You see, without getting the background of the fact, this will be difficult.
Lordship, read the judgment, my lord. So I have read the judgment. Now I'll be placing it.
See, this is your case. You please place the facts. You see, it is not that.
Lordship, page 4. It was alleged that the complainant, Dr. Dinesh Bhatia, was indulging. This is the original complaint, my lord. I'll be reading my petition annex is that, my lord. The original complaint by the Professor, by the Raghavendra Pratap Tripathi is annexed, my lord.
My lord, may I read page 30? That is the original complaint, my lord. That will reveal the facts, my lord. Page 30.
Court must get the fact, you see.
My lord.
Lordship, it is page 9, my lord.
Page 30 is
which way section 24 becomes relevant in this case? That is.
My lord, it is relevant because my lord may kindly read, my lord may kindly peruse the wherein the protection was given, my lord, by the act, by the statute. My lord, it is section 8.
Yes, sir. Let us come to the complaint before we come to all those points of law. Where is the complaint, Dr. Majika?
Page 30, my lord.
30.
My lord. Annexure 2.
Yes. Let us try to determine who is bride giver and who is bride refuser.
Should I read, my lord?
It's a quite big problem. Yes.
Mr. Kazim permits, I can read because this is creating some problem through online.
Yes.
My lord, this is dated 22/11/2018, my lord.
Yes, we are just going to the complaint, Mr. Kaji would just request Mojika to do that because you are online. You are online. You see, there is a difficulty in hearing. So,
my lord, I'm sorry. I'm sorry.
See, the person who is physically present, you get him clearer. You see, much more clearer.
I'm
getting Dr. Mojika to just.
I'm little indisposed because of my BP, my lord. Otherwise, I would have physically appeared.
This is otherwise difficult, like online mode. For this court, you see, to properly appreciate the submission becomes quite difficult. But then since it's a system now, so there is no other option. Anyway,
I'll simply read. I'll not make any submission. I'll simply read the FIR.
Just requesting Dr. Mojika to read out the thing. Yes, please.
This is dated 22/11/2018.
Yes.
From Raghavendra Prasad Tiwari, Department of Biomedical Engineering, Malad.
Yes.
I addressed to Superintendent of Police CBI a complaint against Dr. Dinesh Bhatia, Associate Professor and Head of the Department of BME means Biomedical Engineering Department, Malad, Nehu, Shillong. I am pursuing PhD at the Biomedical Engineering Department, Nehu, and also functioning as a Junior Research Fellow in Department of Biotechnology, New Delhi. Government of India sponsored project titled Design of Neural Network Based Pacemaker at Biomedical Engineering Department, Nehu. The principal investigator PI of the above mentioned project is Dr. Dinesh Bhatia, who is also an associate professor and head of the department of BME. Being principal investigator of the above mentioned project, he is my controlling officer. Being principal investigator PI and HOD, Mr. Dinesh Bhatia is indulging in corrupt practices like sanctioning of false bills for a long time. Dr. Dinesh Bhatia has contracts with firms namely SK Enterprises, Riddhi Medical Store, Vidyavanshini Enterprises, AK Enterprises, etc., all situated at Sonabhadra, Annapara in Uttar Pradesh, in whose names Dr. Dinesh Bhatia sanctions fake false bills for having purchase of medical electronic items. In fact, no such medical electronics items are being received by Department of Biomedical Engineering, Nehu. Dr. Dinesh Bhatia himself has sanctioned such bills, being the competent authority. Dr. Dinesh Bhatia puts me under constant pressure to prepare such false fake bills and asks me to process the bills. After sanction of the bills, payments are being made to the firm in whose name false bills were prepared and sanctioned for supply of the medical electronic items to Department of BME, Nehu. In fact, no such items were received by Department of BME, Nehu. Thereafter, Sri R. Gupta, phone number so-and-so, the representative of the aforesaid firms pay the bill amounts to Dr. Dinesh Bhatia after deducting his commission by transferring the bill amount in my accounts. Later on, Dr. Dinesh Bhatia asked me to withdraw the money from my bank account and hand over to him. I am maintaining bank account bearing number so-and-so with Axis Bank, Lucknow branch, Uttar Pradesh. In this regard, I again submit that Dr. Dinesh Bhatia put me under constant pressure and threatens me that if I do not follow his instructions to deposit the illegal money in my account and to pay him in cash after withdrawing the amount from my bank account, he'll discontinue my fellowship and get me debarred from my PhD. Due to constant pressure and threats from Dr. Dinesh Bhatia, now I am depressed and under tremendous mental pressure, and I do not want to facilitate corrupt practice of Dr. Dinesh Bhatia henceforth, and therefore lodging this complaint regarding sanction of fake false bills and demanding amount thereof from me, which had been deposited in my account by Sri R. Gupta. I have been recording my conversations with Dr. Dinesh Bhatia for quite some time in order to collect the evidence to prove my innocence. These recordings are available with me in my micro SD card, which I can hand over to you if required. Recently, Dr. Dinesh Bhatia told me to prepare bills of amount of rupees 1,30,000 approximately in respect of supply of medical electronic consumables, items which has not been actually supplied by Mr. SK Enterprises, Riddhi Medical Store, Vidyavanshini Enterprises. As per his instruction, I prepared the bills and submitted the same to Dr. Dinesh Bhatia, who has sanctioned these bills which within his competency. After sanction of the bills, payments have been made to Mr. SK Enterprises, Riddhi Medical Store, Vidyavanshini Enterprises during the period from 4/11/18 to 14/11/18. I had visited my native place, village Syamdaspur, Hardoi, Uttar Pradesh for Diwali before proceeding on leave. Dr. Dinesh Bhatia ordered me to collect cash of rupees 50,000 from Sri R. Gupta, the representative of the aforesaid firms. According to the instruction of Dr. Dinesh Bhatia, I contacted Sri R. Gupta, but he told me that at that time he did not have cash but will transfer the money to my account on account of Dr. Dinesh Bhatia. After resuming my duty from leave, I joined the office on 15/11/18. On that day, I told Dr. Dinesh Bhatia that Sri R. Gupta had not given cash but told me that he will transfer the amount of rupees 90,000 to my account or the account of Dr. Dinesh Bhatia. On this, Dr. Dinesh Bhatia instructed me to ask Sri R. Gupta to deposit half of the amount immediately in my bank account, and about remaining, he told me to wait for further instruction. However, I did not ask R. Gupta to transfer or deposit the money on that day. On next day, 16/11/18, Dr. Dinesh Bhatia again instructed me to inform Sri R. Gupta to deposit the money in my bank account. Hence, in presence of Dr. Dinesh Bhatia, I made call to Sri R. Gupta and told him to deposit cash of rupees 45,000. On 19/11/18, an amount of rupees 35,000, rupees 5,000 and 5,000 were deposited in the aforesaid bank account with Sri R. Gupta. On 20/11/18, Dr. Dinesh Bhatia asked me whether R. Gupta had deposited money in my account. In this regard, I informed him that R. Gupta has deposited amount to rupees 45,000, but Dr. Dinesh Bhatia did not ask about withdrawal of money as he was busy in some urgent matter. Today on 22/11/18, when I visited the office of Dr. Dinesh Bhatia Nehu, he asked me to withdraw cash of rupees 40,000 to be given to him. However, today I could not withdraw the cash as I am holding the bank account with Axis Bank Lucknow branch UP. Therefore, I opened new account number so and so with Axis Bank Hitting Road Shillong, where I transferred rupees 40,000. Subsequently, I withdrew rupees 40,000 from the ATM, which was deposited in my earlier account by Sri Gupta towards payment to Dinesh Bhatia. Accordingly, I informed Dr. Dinesh Bhatia on this mobile about withdrawal, who has instructed me to hand over the case to his office tomorrow on 23/11/18 at 11 hours. I want to say that all the earlier proceeds of fraudulently sanctioned bill of Dr. Dinesh Bhatia have already been handed over to him fully after withdrawing from the bank accounts as per his instructions in the past, and I have not received any share part thereof from his directly or indirectly. Henceforth, I do not want to associate with the legal activities of Dr. Dinesh Bhatia under his pressure and threats, and want to stop these criminal activities which are against the interest of Nehu. Therefore, I do not want to hand over the above mentioned rupees 40,000, which is illegal money as detailed above, and be a part of this criminal act of Dr. Bhatia. Therefore, I am submitting this complaint and request to take necessary legal action against Dr. Dinesh Bhatia.
So here the bribe giver is R. Gupta.
Bribe giver is R. Gupta.
Yes.
Deposited. He's not before, but his charges have been framed against him.
Yes. And he is the accused who is not before this court.
Yes, my lord.
Yes.
My lord, now can I submit, my lord?
Yes, please.
My lord, may kindly peruse Section 8 of the PC Act, my lord. Section 8 of the PC Act. Subclass 2. Lordship got it? Section
Yes.
8. I'm not reading entire section, Your Lordship, but I'm reading subclass 2 proviso. Provided further that the person so compelled shall report the matter.
Wait. Section 8.
Yes, my lord. 8.
Subclause 2.
Subclass 2, it's proviso, my lord. It's proviso. Section 8 begins from page 10, my lord, of the PC Act, and then page 11.
Subclause 2 is nothing in subsection 1 shall apply to a person.
No, my lord. Lordship may kindly hear me. Proviso is, my lord, provided further that the person so compelled.
Where is subclause 2? Subclause 2 starts with what?
Is subsection 1, my lord.
To reward with public servant for improper performance of the public
subsection 1. There is a clause 2.
That is what exactly. Subsection 2 is something different.
My lord.
So this is the problem, you see.
So, my lord. So
see, subsection 2 is different. You see, you read it correctly. You are not reading it correctly, Mister.
My lord, I'm whole reading. Any person who gives and promises to give an undue advantage.
See, subsection does not start by that. First, locate. Please locate first. What is subsection 2? Section 8, subsection 2.
I'm reading
subsection 2 start. See, subsection 2 starts with nothing in subsection 1 shall apply to a person. It is not what you are reading.
Lordship, it has also been amended, my lord. I'm reading the amended section, my lord. Amended section. Offence relating to bribing of a public servant, my lord. Is that heading? Lordship got it?
Yes.
Any person who gives or promises to give an undue advantage to any other person.
Yes.
Or persons with intention to induce a public servant to perform improperly a public duty or to reward such public servant for the improper performance of the public duty shall be punishable with an imprisonment for a term which may extend to 7 years or with a fine or with both.
Yes.
Provided, this is formula of the bribe giver, provided that the person of this section shall not apply where a person is compelled to give such undue advantage, provided, this is a provision, provided further that the person so compelled shall report the matter to the law enforcing agency, authority, investigating agency within a period of 7 days from the date of giving such undue advantage, my lord.
Yes.
So this is the clause. And if it is, then section 24's protection was there, my lord. So he has neither informed within 7 days, my lord, to the law enforcing agency about such.
Where we are, perhaps, see, getting your argument is very difficult. See,
my lord, my submission is the learned trial judge should have considered these two arguments which I have argued before the court.
that is nothing to show that you have argued those matters before this court. Before that
So,
court.
my lord, when the learned trial judge has not even mentioned,
if you maintain that, you go to the Lalde trial court fast and file a petition there, and that probably, if you look, you will find some judgments which says that if you contend there is some mistake in the judgment of the trial court, then it is the trial court where you should raise it first. You just cannot.
So, Lordship may kindly pass a direction that my plea should be taken down.
No. We will not pass any. We will not pass any direction. Why should we pass a direction?
My lord, when the statutory provisions, my lord, statutory provisions, section 306, my lord, and the grant of pardon cannot be done in PC Act under section 306, my lord. I will be reading section 5 where the procedure and powers of the special judge is there. Section 5, my lord. I shall again read, my lord. Section 5, my lord. Lordship may kindly peruse section 5. A special judge may. Lordship got it, section 5?
Yes.
A special judge may take cognizance of the offence without the accused being committed to him. I'm sorry, for trial, and in trying the accused shall follow the procedure prescribed by the Code of Criminal Procedure for the trial of the warrant by the magistrate.
Yes.
Subsection 2. A special judge may, with a view to obtain the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence, tender a pardon to such person on condition of making a full and true disclosure of the whole circumstances within his knowledge relating to offence to any person other than other person concerned, whether a principal or abettor in the offence thereof, and any pardon to so tendered shall, for the purposes of subsection 125 of the section 308 of the Code of Procedure 1973, be deemed to have been tendered pardon under section 307 of the Code, my lord. Now, my lord, this is the real section, my lord. So, who will decide who is this witness, the accused Raghavendra Pratap, who was initially filed arraigned as an accused by in the charge sheet by the CBI. Initially, my lord, Raghavendra Pratap Tripathi was arraigned and accused in the charge sheet by the CBI.
Yes.
So who and the CBI arraigned him as an accused because of the protection of section 24 has gone. Otherwise, he could not have been arraigned and accused in the charge sheet, my lord.
Then what?
So,
what is the bearing?
Lordship,
See, a person has been made an accused, and subsequently he was given pardon by the court on the condition that he becomes an approver. Then that is what? That is the thing. Then what relevance your submission has here?
It is the investigation.
Why a person has been made an accused, has not been made an accused? This court will not go into all those questions. Why should we go into all those questions?
So what I am saying is, my lord, the learned trial judge is to decide the application within the framework of the section 8 and section 24.
That if you have not...
I have raised, my lord, those.
No, section 4, section 21 not coming here. Why
section 5, subsection 2.
My lord, he is the bribe giver. And he is the bribe giver and he was compelled, my lord.
We have been directly also concerned. You see, I do not know why, with due respect to the Land Council, it becomes quite hard to conceive what this contention is. We are not going, see, we are in a revisional jurisdiction, isn't it? We are just going by the fact that one person was an accused. Whether he has been made rightly made accused or not made accused, we are not going to all those questions. We are saying that person was an accused, and subsequently he was granted pardon on the condition he become a approver. That is the fact, isn't it?
It is not
Now,
CBI, my lord. I'm sorry,
my lord, their
CBI,
case, if I
it's a
can,
court.
their case, my lord, I heard on the last occasion also. What is their case, my lord? Because section 24 earlier gave a relief to the bribe giver, my lord. Because statement by bribe giver not to subject him to prosecution.
Who is bribe giver here? R. Gupta. R. Gupta is not before us.
So, my lord, our case is, my lord, my friend's contention will not hold, my lord, on 2 counts, my lord. Because number 1, this Tripathi is not a bribe giver, my lord. So section 24 was not applicable, and after it has been omitted,
Exactly.
it's not applicable.
That is what the query of the court. You see, basically, you see, this court has entered into points of law without going through facts. So it was quite confusing at the beginning. Now, after going through the complaint, the things have become clearer. So that is exactly why this court prima facie thinks that section 24 has no relevance.
No relevance. That is one aspect, my lord. The second aspect is, lordship seen section 5 subsection 2, my lord. It gives the court very specific power, my lord. My lord, earlier their case was, my lord, subsection 3 says, my lord, anything inconsistent in PC Act with CRPC, PC Act will prevail, my lord. Now, PC Act subsection 2 itself says that the court has enough power to grant pardon, my lord.
Yes.
And exercising this power, the Honorable Court has granted pardon, my lord. So, in my humble submission, there is no infirmity in the trial court's order, my lord. If subsection 2 was not there, my lord, subsection 2 was not there, then thing would have been, maybe it's an arguable point, my lord.
No, in such a case, CRPC would have prevailed had there been no. See, the thing is, the law is that if any provision is contained in a special law, that will prevail over the
CRPC.
Yes,
my lord.
procedure.
So CRPC,
but then if the act is silent, then the provision of CRPC will apply.
My lord, in CRPC there is enough power, my lord, for the court.
So that is why, by taking into consideration both the provision, with the procedure as well in the special act,
now,
court has the power.
5.2 specifically gives that power also, my lord. So court has double power, my lord, even under CRPC and even under
double power. Single power will be enough.
Lordship, can you submit, my lord? My submission is, who will decide the disclosure, the true disclosure which is yet to come before the trial court?
Yes. That is for the court. That is the discretion of the court below. Court has exercised it, and we do not see there is any illegality in it. So this court is not going to interfere with it.
My lord may kindly appreciate. The section 8 is also there. Why he did not give he was under compulsion.
No, you have
by the.
You have referred to section 8. We have seen it, and we don't find that it will have a bearing there.
Lordship, allegedly the petitioner threatened him to spoil his career if he will not do so. So he should have informed within a week to the law enforcing agency before any offence is actus reus is executed.
Section 8 also would not apply here. There is no question.
Giver, my lord.
Is not questioned.
Lordship, it is very clear. It is very clear where Lordship may kindly again read, my lord.
Who gives or promises to give an undue advantage?
See, it's all right.
Again,
we have.
Permit.
No, we have heard you. See, like, there is no question of repeating the same thing again and again.
Even the bride.
This court finds that, as per the complaint, this Tripathi was never a bribe giver. So section 8 also is never coming here.
No, from his account the money has gone. He has taken out, my lord, from his account.
He says
and he has given the cash.
It's all right. This court is not agreeing with your submission. There is nothing to show. It is rather he was a receiver. He was not a giver. At the best, you can say he was receiver.
Lordship, I'll give judgment on it. I'll give judgment. Yeah. Lordship may give us 2 weeks time. I'll place judgment, my lord, on.
So what is the use after so much of time?
Lordship, I'll place judgment of the Supreme Court on this issue, Lord, whether he is a bribe giver or not.
So you should have placed it today only. You have started the hearing. You should be ready. Should have been ready.
Lordship, I thought I shall be able to persuade this honorable court.
No. There is no question. There is no question. Your thought will not prevail over the requirement.
Please, my lord. I appreciate that Lordship prerogative. So I may be given 2 weeks time, I'll place a specific judgment on it, my lord. A specific judgment on it.
2 weeks or 2 days.
So after that judgment, may I pursue this honorable court, my lord. I'll place a specific judgment on it.
Okay. And if you do not find favorable judgment, we will pass order accordingly.
Please, my lord, definitely, my lord.
Yes. Judgments can be placed tomorrow also, my lord.
Lordship.
You can place the judgment tomorrow, Mr. Can you place the judgment tomorrow? We'll keep it reserved. Place the judgment tomorrow. We'll take it into consideration.
No, my lord, that will not do because for 4 weeks I'm indisposed because of my high BP. Today too, my BP is 100.
Okay. Today you are seeming very all right. You are looking like a very fit man.
No, my lord, that I exercise. That is what I'm able to sit and continue, my lord. Why to tell any wrong before this court, my lord?
Okay, Dr. Modi, just let Mr. Thapa will just okay, Mister. We'll keep it after this thing.
Lord, I can show this.
Write it. Just say on the request of the Learned Counsel for the petitioner, list this matter after 2 weeks.
I'm grateful, Your Honor.
Unnecessary.
Item number 21.